I'm often asked by attorneys what they need to know in order to properly represent a person who has sustained a concussion. Any attorney who is contemplating representing an individual who has sustained a concussion and now suffers from the post-concussion syndrome needs to know that there are many misconceptions about concussions and about traumatic brain injury. First and foremost, the lawyer representing a brain injury survivor needs to know that there is nothing mild about a mild traumatic brain injury. Any brain injury can have serious and lifelong consequences, and concussions are no different. A brain injury attorney needs to thoroughly understand his client's own particular situation and the way that the brain injury has affected the individual's day-to-day activities. It is important to gain a before and after picture of the person's life. The brain injury lawyer cannot be influenced by public misconceptions concerning head and brain injury and needs to understand the following important principles. A person does not need to be knocked out in order to have sustained a concussion, or for that matter, any type of brain injury. One of the best examples of this, and one used in medical schools throughout the country, is the famous case from the 1800s of the railroad worker Phineas Gage. Phineas had a railroad spike go through his scalp and become lodged in his brain. Following the incident, Phineas was walking and talking and never lost consciousness. But unfortunately, Phineas developed a host of cognitive and behavioral problems that affected him for the rest of his life. Next, a brain injury attorney needs to know that the person may be walking, talking, and even exchanging information at the scene of the accident and still may be suffering from a brain injury, even though at the scene they appear to be functioning normally. This is because many brain injuries take hours, days, and even weeks to fully manifest themselves. The changes that take place in the brain don't happen all at once. There is a slow death of brain cells that occurs over time as a result of both chemical and mechanical changes within the brain. Oftentimes, the extent of injury is not realized until the individual attempts to perform complex tasks and tries to return to their normal routine. Oftentimes, it is believed that because the client did not sustain any broken bones, they couldn't have sustained this traumatic brain injury. This too is false. The amount of force necessary to cause an injury to the brain is far less than is required to break a bone. It is the movement of the brain within the skull and the stretching and tearing of microscopic nerve cells that causes the traumatic brain injury to take place. A great deal of force is not required to injure the brain. There are also many misconceptions about the role of CT scans and MRI studies in diagnosing a traumatic brain injury. Many lawyers, insurance carriers, and fortunately even some misinformed members of the medical profession believe that without positive CT or MRI findings, no brain injury took place. This is a common misconception that has long been refuted by well-established medical studies. It is crystal clear that the absence of positive findings on either an MRI or CAT scan does not mean that a brain injury did not take place. These tests simply are not detailed enough to pick up the damage that takes place in the brain. These tests only look at the brain structure and cannot get down to the microscopic level where the damage to the brain has taken place. In fact, these tests are tests of structure and not tests of function. They can't tell if the person is alive or dead or awake or asleep. Another misconception concerns the gross and very general neurological examination. A negative gross neurological exam can't rule out a concussion or the presence of persistent brain injury. The gross neurological exam performed in the doctor's office or in the emergency room is simply not a test of cognitive function and a test of traumatic brain injury. It was never designed for that purpose, and to use it for this purpose is misleading and doesn't make any medical sense. The gross neurological exam tests in very simple fashion the functioning of the 12 cranial nerves. These nerves are not the nerves that are typically injured when a concussion takes place. And to say that no damage was done and therefore no brain injury took place, is an attempt to mislead a jury or to mislead the court. This testing does not test the way we think and how we process information. To obtain this information, we need to have our clients undergo neuropsychological testing. Finally, many attorneys are turned off from representing persons who suffer the effects of concussion because their symptoms and complaints do not follow any particular pattern. But this is really what you would expect following a concussion. Not every victim of a concussion has all the symptoms associated with a disorder known as the post-concussive syndrome. It is the hallmark of brain injury that every brain injury is different, and that every individual may develop different symptoms and symptoms at different times. Sometimes, some symptoms disappear. Other symptoms may take days or weeks or even months to develop. A lawyer contemplating representing a victim or survivor of a traumatic brain injury needs to be familiar with the medical literature and fully comprehend this invisible injury to successfully represent the victims of this silent epidemic. If you or your loved one has sustained a traumatic brain injury, you can call me, Michael Kaplan, toll-free at 1-866-BRAIN-LAW. You can email me at michael@brainlaw.com, and you could get more information about myself and my law firm by visiting our website, www.brainlaw.com.